Article 9. Added political restrictions. Although stated in different ways throughout this Constitution, it must be repeated again here. If this Constitution does not grant a specific power to government, it is an act of tyranny and treason to exercise that political power. All this means is that all powers are prohibited to government unless specifically granted by this Constitution. The relationship between the government's powers and the people's rights regarding these jurisdictions must follow this principle. When the government powers and the rights of the people conflict or are not clear, benefit must go to the rights of the people, unless this Constitution grants to government specific limited power to infringe upon that right. The people are responsible for enforcing this constitutional law upon their respective government officers. Section 1. Religion. Religious institutions, cults, or charitable organizations must not receive any special political consideration than those allowed for any other business or individual. No tax exemptions, etc. Free exercise of religion does not permit breaking constitutional laws or violating others' rights in a religion's name or any God's name. Nor does this exempt any religion or charitable organization or member thereof from paying any taxes according to the same rules that apply to other businesses or other individuals. Section 2. Speech, press, assembly, petition. No laws or other government actions may abridge the freedom of speech, press, or people's right to assemble peaceably, especially, but not limited, to petitioning government for a redress of grievances. Petitioning may include circulating signature ballots, altering the powers and form of government. This does not allow riotous assemblies that exercise threats and violence, blocking lawful business activity. This also prohibits other associated violent actions. This also does not allow for gathering in places that interfere with public travel, such as blocking sidewalks, doors, driveways, or streets, etc. Doing so unjustly violates other people's rights, which is a crime. Speaking, printing, or broadcasting that which may be considered as threats of violence, libel, or slander is protected. However, the harm caused to others violates their rights, which is a crime and can be punished. The person harmed is responsible for seeking restitution via the courts. The line separating harassment from freedom of speech must settle conflicts between one person's right to speak with another's right to not hear or be physically harmed because of that speech. Harm from words usually comes from others who act on those words as if those words are true. This makes both the speaker and the actor accountable for their parts, respectively. The actor, based on the speech of others, suffers the harsher of penalties, as they alone are responsible for their actions. The actor may sue the speaker for damages they incur because they acted on that speech, thus making speakers more accountable and cautious of what they say for others to hear and act upon. Common courtesy, the volume of exchange, the venue where the exchange occurs, and whether the words target a specific person or are merely overheard by one person from another's conversation, among other factors, helps clarify the difference. Communities may rightly set noise, odor, vibration, bright light, and such laws for their general peace of mind, posting such limits at each major entrance to the restricted area, be it sidewalk, street, etc., to the community is required. Section 3. Arms. The first Constitution, the Articles of Confederation, Article 6, Clause 4, it states, "But every state shall always keep a well-regulated and disciplined militia, sufficiently armed and accoutred, and shall provide and constantly have ready for use in public stores a due number of field pieces and tents and proper quantity of arms, ammunition, and camp equipage." Emphasis added. From the second Constitution, the Constitution of the United States of America, Article 1, Section 8, Clause 16, it states that Congress shall have the power to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States of America. To this we include Amendment 2, which states, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Emphasis added. Note the difference between the two constitutions. Under the Articles of Confederation, it was individual states that trained, armed, and stored those militia arms in a public store. With the Constitution of the United States of America, things changed. First, Congress now organizes, trains, and arms the militia. Then, Amendment 2 changes the place where those militia arms may be stored. Amendment 2 declares that the people generally, as opposed to the state government, militia, or standing army, may keep and bear those arms. The individual's right to keep and bear arms must not be infringed by government office or officer for any reason, except when the individual uses and arms to unjustly violate other people's rights. Penalty must apply against only the individual who unjustly violates another person's rights. That's government from passing general laws to restrict society's rights because of those who abuse certain rights. As with all rights, when a convicted person pays their debt in full according to the law, that person's rights must be fully and automatically reinstated in accord with this Constitution. The punishment for criminal acts that use a weapon or threat of a weapon must be 3 times that, as if the same crime was committed without a weapon or threat of a weapon. During the same criminal act, harming more than one person, each person harmed constitutes a separate offense within the same event. Defending self, family, others, and property, when proven, is not a crime. Requiring a person to pass an arms safety class from a commercial or government entity that teaches the proper way to carry, use, care, and maintenance of the specific item purchased are not an infringement on the right to keep and bear arms, as seen in the Constitution of the United States of America, Article 1, Clause 16, which empowers Congress to properly train the militia. A requirement to do so does not extend to simply owning or possessing the arms, much the same as the owner of the vehicle need not know how to operate it if they hire others to do so for them. The people who operate either arms or the vehicle in public places must be trained in order to better ensure the safety of the general population. Arms safety classes are a public safety measure and falls within the well-regulated militia criteria in accord with the Constitution of the United States of America, Second Amendment. Any person carrying an arms in public must have demonstrated that they are at least qualified as a sharpshooter or better at a paintball live-fire qualifying range, thus demonstrating that the qualifier has the ability to hit their intended target, their selected arms, while being fired upon by others. Public safety measures require individual pass driving tests, properly operating vehicles in public, so as to maintain an organized traffic flow. Other similar restrictions on individual rights must be amended into this Constitution on a case-by-case basis. Some additional occupations that require testing include medicine, mechanics, utilities, and other public hazardous occupations to make certain that the people are skilled in those professions. With respect to arms, for clarity, this 1785 Common Use Dictionary definition for arms is carried forward into this Constitution. Arms. 1. Weapons of offense or armor of defense. The proper enforcement of the 1787-1790 Constitution of the United States of America, Amendment 13, use of slavery and involuntary servitude for punishing criminal activity, carried forward into the Constitution, works to reduce all type of crime, so long as the person is duly convicted. More later in slavery and involuntary servitude. Section 4. Militia. Well-regulated, professionally trained militia that respect the people's rights are necessary to maintain the security of a free people, city, county, state, or nation. Citizens forming private militia remain subject to the unanimous declaration, this Constitution, and other constitutions listed herein, as well as the local jurisdictions' laws wherein they meet, so long as these laws are made in pursuance of this Constitution. The militia, as well as city, county, state militia, are subject to serve the people of the United States of America, the state, the county, and city wherein they organize and train. When called into service, the members must be compensated at the same pay rate for the time served as the regular military and police force, not at an increased rate of compensation. The higher rate of compensation creates loyalty to pay than to the people's rights. The idea is to prevent a criminal guns for hire mercenary situation. Section 5. Soldiers. Entering. Whether in wartime or peacetime, no soldier or other government officials may be quartered on any private property without the owner's and lawful occupant's consent. A citizen who does not condone the war should not be forced to support it. Section 6. Personal security, privacy. The right of the people to be secure in their person, houses, businesses, transportation, papers, banking, communication, and other effects, whether electronic, written, or other modes of storage against unreasonable searches and seizures, must not be violated. This prohibits government officers from looking into windows of parked vehicles or buildings hoping to find evidence of prohibited activity. However, if unquestionable criminal activity is clearly seen or heard to be in progress, the officer is duty-bound to stop the activity and detain the actors until determined whether the acts are criminal or consenting. The only use of this limited government power to invade any person's privacy is for finding and punishing people for criminal activity. It has no other use than ensuring justice. No warrants may issue but on probable cause that a crime was committed. Probable cause is only enough to get the warrant, not enough for an automatic search. The warrant must be supported by oath or affirmation naming the person or people who witnessed the crime, particularly describing the place or persons to be searched and the persons or things to be seized, along with identifying the witness who reported the sought person or items. When referencing a reasonable search, there must be a constitutional reason for the search. The search itself must be conducted in a reasonable manner so as to not unnecessarily damage private property, which means that care must be taken when disassembling or opening an area so as to not damage it. Unnecessary damage, when proved, will be compensated at full replacement value through the paychecks of those involved in causing the unnecessary damage. The government officers are responsible for returning the property to its original condition after the search. Neither this nor any part of this Constitution may be violated even during war. Time demands the highest regard for maintaining the constitutional rule of law. Probable cause is not to allow an automatic search without a warrant unless conducted for the sole purpose and only done sufficiently enough to reduce a presently occurring criminal or violent act so that the warrant may be obtained for additional searches if required. Once the person sought is in custody, detained, or cuffed, any fingerprints, DNA, etc. testing must have a warrant detailing why the evidence is required. This is to stop Swiss invasion and fishing expeditions simply because police or other government officers do not recognize the person. Warrants may be electronically transmitted from the signing judge to field officers to be delivered to the person detained. Any item discovered during the disarming, unless identified as part of the crime for which the person is sought and searched, must not be caused to obtain a warrant for extra searches unrelated to the original cause. Officers witnessing a crime in action should detain offenders and secure the area, making certain those apprehended are unarmed or at least restrained. This does not authorize additional searches of the person's bags, vehicles, persons, etc. without a warrant. Once detained and the area secure, the officers should obtain a proper warrant naming and accurately describing the persons and or places to be searched, and naming the persons and or places and or things to be seized. Under this Constitution, naming includes giving a written physical description and or photo and or accurate sketch of the person detained if they refuse to identify themselves. Once detained, held for trial, etc., the person is allowed to remain in their own clothes without removing strings, belts, medicines, etc. At this point, they have not yet been convicted of any crime. The individual is responsible for their own actions toward themselves. This requires single occupant cells. Section 7. Searches. Evidence from searchers without a warrant must be allowed in court so long as the searchers receive prior written consent from the person to be searched and or from the owner and occupant of the place to be searched. The written consent must include the place to be searched and the item or persons sought, the person or things to be seized, and at least 2 independent witnesses or 1 notary to witness signatures. All searches must allow for counsel or other independent witnesses to be present should the person to be searched or the property owner and or occupant of the place to be searched make such a request. Additionally, any concerned passerbys may view and record any action by government personnel, so long as they do not interfere with the movement of the officers and are not in the immediate evidence-gathering area. Officers keeping the public away from a scene, out of camera and recorder range, is a violation against the free press. The people who interfere with the curing of evidence can be arrested for obstructing justice. Vocalizing concerns about police activity is not interference. When used, the term legal guardian does not include teachers, religion leaders, babysitters, or others who might have short-term temporary care of the child. Without a court order, only the parents or legal guardians can search or grant permission to search a person who is not yet 18 years old or who is not yet legally emancipated minor. Even with a court order, the parents or legal guardian must be present during the search and questioning unless the person is actively committing any type of crime, which is defined as violating others' rights and or any constitutionally authorized law, or as suspect is fleeing an armed and or otherwise violent crime. A minor or a person who is not yet of an adult age or is not a lawfully emancipated minor may not lawfully authorize property or personal searches. Minors may not lawfully consent to a search without the parent or legal guardians present. In emergencies or rescues, the minor should direct officers to where assistance is required. Rendering such assistance is not cause for unrelated searches. Section 8. Found evidence. Evidence found in public locations that are not on private or commercial property must be considered as lawfully obtained. Locations such as rented or borrowed locker space, whether from private, commercial, or government facilities by non-government employed citizens, must be considered as private. Government officers, lockers, or operations must be considered public places regardless of whether they lease or rent from a private or commercial entity. The evidence found through any search that violates this Constitution must be presented in court for jury examination to determine its relevance and admissibility for the trial. The offending searchers must be prosecuted for the unlawful search and or as an accomplice to the crime, especially if the violations allow a guilty person to escape justice. Upon conviction, each person involved in conducting an unlawful search must serve a mandatory 1-year sentence for violating each searched person's rights. Each person or place unlawfully searched is a separate violation. The intent is to reduce the likelihood of government officers covering the crimes of fellow officers, regardless of government branch or level. Section 9. Return of property. After the jury delivers their verdict, all seized property must be returned within 30 days to the rightful owner. All money seized must be returned with interest paid at the highest bank rate available to the public at any public banking establishment within the subject jurisdiction during the time the money was seized, provided the defendant is found innocent or not guilty. All stolen property must be returned to its rightful owner within 30 days after the trial concludes. In all other cases where the jury delivers a guilty verdict, the next larger political jurisdiction must auction the seized property if it does not belong to the victim of a crime. The next larger political jurisdiction officials must advertise the seized items to be sold and must sell the seized property at a public auction established by the people of the lower political jurisdiction. The receipts from selling seized property become part of the general fund of the political jurisdiction that is next larger than the one that auctioned or sold the items. This prevents a political jurisdiction from unjustly seizing property to bolster their own various funds. Section 10, Capital Crime. No person should be detained while awaiting trial to answer for any crime, no matter how minor or serious the crime, unless required by a grand jury. A grand jury is 24 or more impartially and randomly selected people in the area at the time. Members for a given grand jury must be chosen at random, and 4/5 of the members must consider that there is enough evidence to bind the accused over for trial. The accused must be notified of the grand jury meeting and should be present to address the charges and potentially prove innocence, so that officials might focus their search on other probable suspects. Section 11, Double Jeopardy. No person should be subject for the same offense, action, or inaction to be twice put in jeopardy for the loss of life, limb, liberty, or property. Double jeopardy must include a combination of criminal and non-criminal accusations and trials resulting from the same action or inaction. If those trials are considered separately, this requires that all criminal and non-criminal trials regarding the same person and their action or inaction be held at the same time. Section 12. Self-incrimination. No person may be compelled in any criminal or non-criminal case to be a witness against themselves or to provide evidence that might incriminate them. This expressly outlaws the use of plea bargaining. Nor should any person be deprived of life, limb, liberty, or property without due process of law, which prohibits the use, among other unjust government powers, of eminent domain, civil asset forfeiture, and or holding a person in jail for trial for any time length without a grand jury indictment. Section 13. Eminent domain, civil asset forfeiture. No property may be taken from the rightful owner except in criminal and non-criminal prosecutions for which an impartial jury decides the one party owes restitution to the injured party. This aspect is not a taking for public use, as it goes directly to the victim. Taking private property for public use must not be an option in a free and responsible society. Private land or other items must not be taken from its rightful owner for public use, except through taxation that equally applies to all others in the same political jurisdiction, according to the rule of law detailed in this Constitution and lawfully authorized by the people. The people are responsible for developing alternatives that do not involve taking private property without the owner's consent. Compensating a person injured or wronged by the person from whom the jury orders restitution is not considered a public use. No property may be taken from a person based on the faulty assumption that if criminals possess certain items or certain amounts of cash, etc., that any person possessing that item or amount is guilty, or that they might use those items for a crime. This prohibits what is known as civil asset forfeiture and other types of these laws. Section 14. Trial by jury. In all criminal prosecutions, without exception, the accused must receive a speedy and public trial by an impartial jury within the jurisdiction where the crime was committed. This prohibits plea bargaining, as the only benefit from such bargains are the guilty, as well as corrupt government officials. The law passed must state the original jurisdiction. The definition for speedy and quick from 1785 must be carried forward into this Constitution. Speedy, quick, swift, nimble, quick of dispatch. Quick. Definition 3. Speedy, free from delay. Definition 4. Active, sprightly, ready. No place in those definitions from 1785 does it hint that the time exceeds more than just a few hours, not days, weeks, months, or even sometimes years without a trial. This right may not be waived by any accused person unless they willingly and in open public court confess to committing the crimes. Nor may any government official deny this right, which addresses the following grievance from the unanimous declaration: for depriving us in many cases of the benefits of trial by jury. Emphasis added. When detained or arrested, the officer must inform the accused of the nature and cause of the detainment or arrest. This must also include the actual reading of the law or section thereof that the accused is supposed to have violated. The officer must audio and or video record the reading of the law violated, as well as allow the accused to audio and or video record the reading if they choose to do so. Also, the officer is to remind the individual that the government cannot force them to offer evidence, fingerprints, DNA, identification, etc., or testimony that might convict them of this or any other crime, unless the officer has a constitutionally authorized warrant that demands the evidence. The officer must, at the time of accusation and arrest or detainment, provide a copy of the full text of the law or section thereof that the accused is supposed to have violated, thus giving the accused the probability of ending the situation by possibly proving that no crime was committed. This is intended to prevent the government from changing the charge after the arrest. When asked by passerbys or observers, the officer must tell the observers of the charges, making it difficult for the charges to change if taken in booking. If the accused person claims the law is unconstitutional, the officer must reference the Constitution, article and or amendment, section that the law supports, as is demanded by this Constitution, and by Article 6 of the prior Constitution, with which the officer provides no proof that the law is constitutionally enforceable, as this information is required to be present in the law before it is passed and enforced. The accused retains the right to question witnesses against them, to gather evidence and witness information for the defense at the time of arrest, or to obtain the assistance of independent counsel for their defense. If the accused is cuffed, the officers must get the names and contact information of all witnesses in the area, and especially those requested by the accused, as well as gather the evidence requested by the defense. If officers challenge the validity of such requests, the officers must call the elected defense lawyer and or the accused person's advisor. If a government officer deliberately allows evidence for the defense to be destroyed, witnesses to be released without gathering contact information, this is an act of treason and tyranny. The government's job is for the truth, not merely for an easy conviction. Section 15, Revoking Immunity. Revoking immunity presently given to family members, clergy, lawyers, doctors, media, foreign government officials, and others with regard to withholding information or evidence of a crime is necessary in an honorable justice system to maintain a peaceable society. Though these people should help the individual in trouble, help does not include harboring or otherwise giving aid and comfort to fugitives by not disclosing constitutionally illegal activity confessed to or otherwise made known to them, especially when those actions violate others' rights or damage others' property. Such immunity qualifies as treason, as this provides aid and comfort to an enemy against the people who can no longer enjoy their safety, security, life, liberty, property, or happiness. If someone reports a crime to you, including whether or not you are a religious leader, a doctor, lawyer, or other previously exempted group, you become an accomplice unless you report that information to the law enforcement agencies. Let the criminals live with their own conscience about the crime. Reporting should be done in less than 72 hours, as opposed to years or decades later, when the accused gets rich and or famous and or politically powerful. Planning, thinking about, writing about fictitious crimes, or brainstorming about criminal activity does not constitute criminal activity until the participant also commits the act or knowingly benefits from the criminal act proceeds. With justice, the duty of all involved is to find out what the truth is as it relates to the constitutionality of the law and the crime or accusations at hand. If the prosecution finds evidence that may help free the accused, they must present the information as soon as possible to free the accused. A defense counsel with information, including verbal, written, audio, video, or other form of confession that may help convict their client. The counsel must also make that information available at the earliest possible moment to the prosecution and other court officers. If the accused person does not repeat their confession before the jury in an open court, the confession must not be allowed as evidence in the trial. However, evidence obtained according to the rule of law of this Constitution because of the confession must be allowed before the jury. Section 16. Long-form confession. Any confession by the accused must detail the events of the crime committed in long form in open court and before an impartial jury. The confession does not diminish the penalty. A false confession to protect another person must be considered as obstruction of justice and prosecuted accordingly. Section 17. The guilty but insanity plea and guilty under the influence. The guilty but insanity or under the influence pleas is an automatic admission of guilt and must be available for use by any accused person who chooses to use it. The person using the plea must, as best they can, provide a long-form confession as detailed above and be informed of the following conditions attached to using this plea. The convicted person must serve the required jail or prison time with all other jail or prison inmates for similar crimes, and not in a hospital. The person using this plea bears sole responsibility for proving they are sane or no longer under the influence before their release from custody. Even after they serve their full jail or prison sentence and have not proved their sanity, they must be transferred to a mental hospital. Until the person is able to prove they are sane or no longer under the influence, they remain a danger to society and should not be released into society. Section 18. Death sentence. The death sentence, the ending of life, must no longer be available within any jurisdiction under this Constitution. It is easier to restore the rights of a wrongly convicted person while they live than it is after they die. It is better the labor of the duly convicted person to use in ways that benefit society than it is to merely kill the person, no matter how horrid the crimes. When society becomes like the criminal to punish the criminal, society is the criminal. Section 19. Criminal and non-criminal cases. Criminal cases are accusations and prosecutions violating constitutionally enacted legislation, regardless of government level, severity of the prohibited action, or amount of the penalty. These laws generally involve violating the rights, person, or property of others. Non-criminal cases are trials between individuals where an individual's rights and or contracts are violated by another person, business, or government entity, regardless of whether a law exists or not, and the offended person seeks restitution. If the non-criminal claim is connected to a legislated crime, the accused may stand trial for the non-criminal claim or the criminal violations, or both. The trials, if must take place at the same time and be decided by the same jury. All court trials, hearings, and other court proceedings must have an elected judge, an elected prosecutor, and an elected defense counsel present to assist all parties of each case, assisting the court, answering legal and procedural questions, and examining evidence, ensuring justice for all. This must in no way deny a person from obtaining independent advice for either defense and or prosecution. Any interested citizen may also attend and ask relevant questions during the trial because the outcome has an impact on the society and our common rights. The rights of the people to prosecute others for criminal activity, as protected under the Constitution of the United States of America, Amendment 9, shall be honored under this Constitution. The same rules that apply elsewhere herein regarding frivolous cases and the like. The courts are required to simplify the paperwork to a generic format that can be used in every petition throughout the courts. No fact tried by a jury may be otherwise re-examined in any court except where government or jury corruption is discovered, or unless on an appeal initiated by the convicted person who presents new evidence to prove they're innocent or prove that the government violated this Constitution. With the more serious crimes, the courts may refuse bail if authorized by a grand jury. The trial date must be no later than the date requested by the defendant. If the defense has not requested an earlier date, the trial must start no later than 3 to 7 days from the date of arrest. The time incarcerated while awaiting trial must be counted against the total sentence if found guilty. If innocent, the incarcerated person must be compensated at a rate no less than the nation's hourly minimum wage, or $10 per hour, whichever is more, for each hour detained or incarcerated. Section 20. Cost of trial paid by government. The courts must issue a trial date and subpoenas from both plaintiff and the defense. The appropriate sheriff's department must serve in hand those subpoenas to the named party's last known address of record. The court must pay all service fees for both parties. All other fees paid by government via taxes for the prosecution must also be paid or made available for the defense for the same type of expense. To prevent abuse, the jury may determine frivolous abuse by either party and or unjust refusal by the government to compensate a defendant, and may charge any part of or all of the court costs to the party abusing the service. Section 21. Failure to appear for trial. Without a court-approved extension, if a defendant flees the jurisdiction or fails to appear for trial, the courts must accept such actions by the accused as if the accused presented a written document that allows the court to proceed with the trial in the accused person's absence. The court must make note that the named defendant failed to appear. If the accused hired counsel, the hired person, along with the elected defense counsel, must, as best they can, defend the accused. If a witness provides current contact information and fails to appear, the person must be considered as an accomplice to the crime. This is intended to reduce the number of witnesses giving false information or failing to show for trial. In any criminal or non-criminal case where the accused fails to appear in person or through representation when the jury finds the accused guilty, the court must issue an arrest warrant for the convicted person, which includes the demand for return of the convict when found, regardless of what domestic state or foreign state where the accused is found. When captured, the convict must begin serving the required sentence. Any convicted person may present new evidence that may free them. Those who fail to appear possess limited ability after the fact to challenge the credibility of the evidence or recorded witness testimony, and they may also challenge the law on an appeal. In non-criminal cases, if the jury finds one party culpable and they refuse to make suitable plans for restitution at the end of the trial, an order for restitution must issue where financial accounts or real property may be seized to satisfy the judgment, but no benefits or awards may be granted to either party where those damages sought were not detailed in a prior written contract. Section 22. Bail and Punishment. With truly speedy public trials by impartial juries, there is almost no need for bail. Bail and punishment must not exceed that which the enacted legislation requires, and neither cruel nor unusual punishment inflicted. Punishment must not violate this Constitution or other contracts listed in this Constitution. Slavery and involuntary servitude are not cruel or unusual punishment for criminal activity so long as the person was duly convicted, which means that the accused person's rights have not been violated in order to get the conviction. There are many forms of coercion or that of compelling. Coercion or compelling a person to be a witness against themselves may simply be any inducement to get a person to do something they might not ordinarily do. Coercion or compelling a person may be defined as torture, unjust incarceration, or enticement, thus prohibiting plea bargains, as an innocent person is not likely to confess to a crime they did not commit unless they have been held in jail for a period of time to where they risk losing their job, their housing, then their family, etc., etc. All they must do to be released is confess to some crime in order to go home, to work, etc. Otherwise, they may be held longer. Section 23. Slavery and involuntary servitude. Within any political jurisdiction under this Constitution, slavery and involuntary servitude are neither cruel nor unusual in the context of punishing criminal activity. Less dangerous crimes where jail and prison is not required. Community service is part of involuntary servitude. This system prohibits monetary fines as punishment for any type of crime, minor or major. This system prohibits the death penalty, making it easier to restore a wrongly convicted person's rights if they can later prove their innocence. To punish the criminal, all convicts serve hard labor in prison, jail, or community service. The tests to determine whether a particular type of labor or the hours worked are either cruel or unusual consist solely in whether or not the labor and or hours for that type of work are worked by free citizens, whether for hire or volunteering. This Constitution may specifically prohibit types of labor that free people of right may do, such as prostitution, medical, psychological, or other experimentations. Such activity may cause more harm to society by spreading diseases or creating a more violent citizen. Convicts do not receive monetary compensation for their labors and will not receive gifts other than non-physical contact visits and or written correspondence, which must be monitored and recorded. All revenue from convict labor helps with victim restorations, supply the raw materials for inmates to grow their own food, make the fabrics for their own clothing, bedding, etc., provide products and services for other government offices and agencies, such as help to widows, orphans, and elderly, to reduce the tax dollars to operate government as well as to pay for maintenance to the jail and prison facilities. With this practice, jails and prisons provide the hands-on skill-building education, encouraging the hard work habits and the understanding that crime no longer pays in the U.S. of A. The free people also benefit in that they no longer pay as the victim and the taxpayer. The convicted person also benefits, if innocent, by still being alive to prove their innocence, in addition to useful skills they acquire. The wrongfully convicted person is compensated for their wrongful incarceration, detailed earlier. Section 24, Due Process and Equal Protection. No law may infringe upon any individual's rights, except in cases specifically stated within this Constitution, which is for the purpose of seeing that justice has been done to protect the victims of crime. Nor may any person be deprived of life, liberty, or property that resulted from criminal or non-criminal prosecution without due process of law. Nor may any government officer deny to any person, resident, citizen, or foreigner within the jurisdiction, the equal protection of the law. In this way, neither the rights of the victim nor the rights of the accused have unequal priority. Every government official, foreign or domestic, or other person conducting business on behalf of a domestic or foreign political jurisdiction commits any type of crime in this country must be tried, and if convicted, punished, and not allowed to escape justice because of their political connection. Section 25. Other rights retained by the people. Certain rights enumerated within this Constitution are not to be construed in any way to deny, disparage, or otherwise limit or infringe upon other rights retained by the people. The unanimous declaration names some other rights retained by the people, no matter our government forms, but is in no way considered a complete list. Enumerating certain rights within this Constitution works to grant limit, and forbid government involvement regarding the rights listed. Failure to mention other rights prohibits government interference in those rights until such time the governed people amend this Constitution to grant government some limited power or authority regarding those rights. Granting such power must be done in accord with the unanimous declaration statement that to secure the governed people's rights, governments are instituted among men deriving their just powers from the consent of the governed. For any state, county, city, town, or other political subdivision to regulate the rights not specifically listed in this Constitution, that government infringement into the people's rights without written authority within this Constitution is tyranny, despotism, and treason. Allowing government, for the sake of expediency, to regulate rights not enumerated within this Constitution opens the doors to absolute despotism and tyranny by government. With respect to the people's rights and government powers, the people's rights always come first. The question always must be asked, has this Constitution authorized government infringement into that right? If not, that law is unjust. When a right is listed, the smaller political jurisdictions may regulate and punish those activities with more leniency, but not more harshly than this Constitution allows. When it comes to political powers granted within this Constitution, the smaller political jurisdictions may more strictly limit their local government's exercise of those powers. Otherwise, the powers are off limits to government. Section 26. Military Authority. Every political jurisdiction under this Constitution must be able to freely investigate any government officers and acts within any other political jurisdiction under this Constitution in order to fulfill their constitutional oath toward securing and protecting their respective resident citizens' rights. Whether larger or smaller, each political jurisdiction's law enforcement, police, sheriffs, militia, and military are subject to the other's civil authority, except when constitutionally investigating those civil authorities. The investigated jurisdiction must cooperate with investigations. All investigations must be public, remaining subject to the rule of law provided by this Constitution and the other contracts listed in this Constitution. Law enforcement and military persons must suffer penalties for enforcing laws and following orders that violate the supreme law of the land as detailed within this Constitution. To enforce unconstitutional laws or follow such unconstitutional orders is an act of treason, giving aid and comfort to an enemy, a domestic enemy. These treasonous acts must be punished so as to discourage others from repeating them. Section 27. Unlawful entry into nation, illegal immigration. Anyone suspected, by primarily not being able to communicate in the United States version of the English language, of having entered these United States unlawfully or having overstayed their visa, may be asked to present identification. Government officers patrolling the nation's borders, they will audio-video record the people crossing into the nation illegally. When captured, they are brought directly to the nearest immigration court for jury trial. If duly convicted, they must serve their entire sentence, slavery and involuntary servitude, before being returned to their home country. When the individual cannot provide appropriate identification, but claims to be a citizen, the detaining law enforcement officer must seek verification from other state and/or federal agencies obtaining copies of birth records and or naturalization papers, passports, visas, etc. This should be accomplished in less than 3 hours. During this time, the individual must also be allowed to make any calls to have pictures presented to local law enforcement agencies or faxed to the detaining officers for verification. If the law enforcement agency detaining the individual cannot acquire any documentation, the accused must receive a speedy public and impartial jury trial. If the jury finds the accused guilty, those convicted must serve 6 months for the first offense and 2 years for the second offense in jail or prison, working hard labor alongside convicted persons before being returned to their home country. The individuals charged with other crimes, additional trials must be held regarding those charges. The political jurisdiction where the crimes and or the trial take place must use their general or judicial fund to pay all trial costs. If convicted, the person must serve the appropriate sentence for each crime, as detailed in the law. Sentencing must be the same as if a lawful citizen committed the same crime. Each sentence, each convicted offense must be served one after the other. Whether a person is a citizen or a foreigner in this Constitution's jurisdiction, lawfully or not, all persons convicted of separate crimes must serve consecutive sentences, one after the other. Anyone convicted of unlawfully entering or living within this Constitution's jurisdiction must also be prohibited from re-entering lawfully for at least 10 years after being returned to their home country, after they serve the entire sentence for which they were duly convicted. Each time a person enters this Constitution's jurisdiction unlawfully, the penalty doubles. This same doubling applies also to other criminal acts, whether the person convicted of that same crime is a citizen or not. This doubling must not be construed so as to apply to different types of crime, such as robbery equals robbery by any other name, and murder equals murder by any other name. But robbery does not equal murder, and self-protection does not equal murder, etc. And just for clarity, no crime is committed out of love, so lumping many different types of crime under the same umbrella, such as hate crimes, so that harsher penalties may be applied, must not exist. Regarding illegal immigration, before this article on illegal immigration becomes enforceable, a 90-day notice must broadcast publicly more than 3 times daily at random hours for the entire 90 days. Being broadcast in the United States of America version of the English language, foreign countries are responsible for accurately translating this to their citizens. Section 28, Common Language. For unification and cost-effective government, as well as cost-effective business, every citizen resident must be able to read, speak, understand, and otherwise communicate in the United States of America's version of the English language. The United States American English language includes International Sign Language and International Morse Code that can be used by the blind and or deaf. This skill benefits all resident citizens in emergency situations. People who cannot communicate in the United States American English language retain sole responsibility for hiring an interpreter when dealing with any government office or business within these United States of America. This language requirement violates no person's rights, as it supposes all persons voluntarily come to or remain within these United States of America. If not, they may freely leave or surrender their citizenship, and the people unlawfully detaining them will be prosecuted for kidnapping and false imprisonment, so long as they are not being detained for any other crimes or convictions. This requirement must not be construed in any way to prevent citizens from learning other languages or participating in their desired culture, so long as such practices do not unjustly infringe upon other people's rights or the laws enacted within the consent of the governed guidelines of this Constitution. Section 29, exercising the right to vote. The resident citizen's right to vote or to receive benefit from any government program or agency offered within these United States must not be denied or abridged by any political jurisdiction or agent under this Constitution, except as authorized within this Constitution. Government officers must require an individual to prove eligibility to vote in that, are they a citizen, or are they a citizen taxpayer? Citizenship requirements, in that they are, in fact, a lawful citizen. Based on residency requirements, in that they lived in the political jurisdiction long enough. The citizen pays any taxes at all, sales, income, etc. Are they registered as a voter? In addition to residency, taxation, and citizenship, no other reasons may exist to prevent a person from voting once they have passed the public vote test detailed earlier and cleared the exclusions from voting. Section 30, exclusions from voting. Any person still serving a sentence or any part thereof for any criminal activity or non-criminal acts that violated other persons' rights is prohibited from voting. The same individuals are ineligible for other government programs. Once the sentence has been paid in full, no parole, no probation, no community service, etc. Only then are the rights of the citizen fully restored, unless the citizen prove to be a repeat offender, which the law must specify, after which number of repeat offenses the citizen permanently loses which specific rights related to the repeated crime. Also included are persons who receive government benefits, but this does not exclude honorably discharged military veterans receiving benefits connected with their combat duty service so long as the war was constitutionally declared. A convicted person's family must not become eligible for any government benefits that they were not already eligible to receive prior to the crime. This does not exclude the family from receiving benefits for which they qualified to receive prior to the crime, so long as the family remains qualified under the conviction. Section 31, Right of Personal Association. The people possess the right to choose their associates, whether employees, business customers, church or club members, etc., or tenants or employees of non-government funded businesses or housing, etc., which must not be infringed so long as they publicly post the restrictions in ads, flyers, billboards, posters, etc., wherever they advertise those vacancies. Such postings benefit those who might apply but not qualify according to the offering person's standards. Government funding includes loans, grants, tax breaks, etc., in whole or in part, that any government level or branch has provided to the entity, all of which are prohibited under this Constitution. However, under the previous Constitution, those activities were unjustly allowed. This must not be construed in any manner whatsoever to allow, enable, or encourage criminal activity. Section 32. When rights appear to conflict. When the rights of some seem to conflict with the rights of others, the one's rights should not unjustly violate another or receive greater government favor than the other's rights. Social pressure by way of boycotts and protests effectively regulate socially undesirable practices, business or otherwise, especially when no person or property are physically harmed. When government force causes one to surrender their right to favor another person's rights, this is not justice. In a free, socially responsible society, there are nearly always more options available than seeking the government's strong arm to violate the one to favor the other. As for government, the actions of government personnel, as it relates to their government occupation, they have no rights regarding which citizen can and cannot benefit or government products or services. Taxation. Through the legislative powers described within this Constitution, the people within a political jurisdiction who enact legislation must decide the amount and forms of taxation with regard to how they will fund that for which they consent, if in fact 2/3 of the total body of registered voters do consent. Only that political jurisdiction's resident citizens are responsible for funding what they authorize. Any citizen, no matter their age, if they pay any type of tax, fines, government fees, levies, and such, they possess the right to vote, so long as they are a citizen. Section 34. Grant of power. Because history's worst parts repeat too often, this statement must also repeat throughout this Constitution. No official in any government level or branch under this Constitution may obtain any power or authority that the people subject to its jurisdiction have not already specifically granted to that government branch or level in writing via the respective Constitution, so long as that grant of power does not also violate this Constitution or the unanimous Declaration of the United States of America.